Every day in the USA, people find themselves in court.
A person at the jail, please state your name for the record.
Clayton Joseph Mosier.
This is case number 26-1840-FY, the people of the state of Michigan versus Clayton Joseph Mosier. Mr. Mosier, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
It was, Your Honor.
And did you have the opportunity to meet with somebody from the Public Defender's Office today?
I did this morning, Your Honor.
All right. I have a complaint that alleges that on or about May 17th, 2026, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years in prison or a fine of up to $5,000 and DNA to be taken upon arrest, and consecutive sentence may be imposed if it happened in a place of confinement. Do you understand those charges and the potential penalties?
I do, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
I would like to request the appointment of one, Your Honor.
All right, the court will make a referral to the Public Defender's Office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. Historically, counsel, I show some juvenile convictions, but nothing as, I shouldn't say convictions, adjudications, but nothing as an adult. The praxis scores him at a risk level 2. Any comment regarding bond, Mr. Schatz?
Thank you, Your Honor. I had the opportunity to speak with Clayton earlier today. He reported to me that although he's only been living at his current residence for 2 months, he spent his entire life living in the general Wexford Cadillac area. He is currently employed at McDonald's, the one on the highway on the west side between the lakes, where he's been there for about a week. So he is concerned that should he not be able to take bond, that he will lose that job. He was just laid off from a position at Board Warner about 3 weeks ago, and he had expressed difficulty finding replacement employment since then. I would also highlight that his entire family is here. He has support here in the gallery as well today. From what I understand, he has some siblings. His mother and his grandparents all live in the area. He explained to me how he acts as a semi-caregiver for his grandmother, who recently suffered a stroke, and that he is recently making efforts to receive his GED equivalent here in Cadillac. I do not believe he is a flight risk, and we believe that any sort of bond conditions may alleviate any threat that the people find to him, to the general public. We would respectfully request a PR bond. Thank you.
Thank you. Ms. Lawrence?
Your Honor, this attack occurred at the Blackburn State Park just before 1 o'clock in the morning. The victim went looking for his minor stepson at the park when he encountered the defendant. An argument ensued and the defendant pulled a knife on him. The victim did suffer a 6-inch laceration on his upper abdomen, as well as a 2-inch laceration on the mid-center of his back. At this point in time, I would ask for a no contact order with the victim. I would also ask for a no weapons and firearms provision. While I do understand his praxis is only a 2, I think he clearly is a danger to the community. This was a violent attack that occurred in a public park. So I would ask the court to impose a $50,000 cash surety bond. Thank you.
Thank you. The court understands the praxis scores the defendant at a risk level 2. However, I do not believe that the praxis adequately scores the seriousness of this offense. The praxis only asks if it's a felony that the defendant's charged with. However, this is an intent to do great bodily harm less than murder, which is a 10-year felony. So I don't believe the praxis score is appropriate. I do realize that this is Mr. Mosier's first allegations in the adult world, but he is not a stranger to the criminal justice system, as he has had some juvenile adjudications. By my count, it looks like 2 that were actually adjudicated, and then perhaps 2 that were dismissed due to an intensive probation. I do find that, as presented to the court today, Mr. Mosier necessarily doesn't present as a flight risk, but I do find that he presents as a threat. My reading of the probable cause affidavit is that this happened at approximately 1:15 in the morning on Saturday. There was the altercation, there was the stabbing as alleged, and then he threw the knife. However, he was cooperative with law enforcement and told them where that knife would be located at. Barring that, though, I still do believe that he poses as a threat. Bond will be set at $100,000 cash surety until I know more, with the conditions that, Mr. Mosier, you are to appear as ordered, keep your contact information current, not to leave the state without permission, and to commit no new crimes. You are not to have any contact with the alleged victim in this case, whose name will appear in the pretrial order. No contact means no contact at all, not by telephone, text, email, social media, or anybody acting on your behalf. You are not to purchase or possess any firearms or weapons, not to act in any threatening, intimidating, or harassing behavior. I'm also, if you do post bond, I'm ordering GPS tether house arrest. I do that because while I don't necessarily find you as a flight risk, at the time that the event is alleged to have happened, that park should have been closed, and there'd be no need for anybody to be in that park at 1:45 in the morning. So I am ordering that as a condition as well. Anything else for the record, Ms. Lawrence?
No, thank you.
Mr. Shantz?
No, Your Honor.
All right, thank you. Thank you, Mr. Mosier. Next arraignment, jail. A person at the jail, please state your name for the record.
Brian Harsh, Your Honor.
This is case number 261661FY, the People versus Brian Leroy Harsh. Mr. Harsh, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, Your Honor.
And did you have the opportunity to meet with somebody from the Public Defender's Office today?
Yes, Your Honor.
I have a complaint that alleges that on or about February 20th, 2026 in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The prosecution has also elected to charge you as a second or subsequent offender, meaning that you have at least one prior drug conviction in your past. That makes that 10-year felony a 20-year felony, and the $15,000 up to $30,000. In the alternative, they are also charging you as a habitual offender 4th offense, meaning that you have at least 3 either attempted or completed felonies in your past. That makes that 10-year possession charge up to punishable by up to life in prison. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, Mr. Harsh, do you plan to hire an attorney, represent yourself, or request the appointment of one?
I'd like to request a court-appointed attorney, please.
All The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea and will set the matter for a preliminary examination. That's a hearing that's held here in the district within 21 days. At that hearing, the prosecutor is required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments and the seriousness of the offense charged. Counsel, historically, I show an 04 possession of prescription forms, in 09 a retail fraud third, and 11 operating while visibly impaired, and 13 possession of meth, drug house, and use, and 13 possession of narcotic less than 25 grams, in 20 possession of narcotic less than 25 grams as a second, and possession meth second. In 15, there was a possession of meth, drug lab, 2 drug labs, and another possession of methamphetamine. In 19, allowing a suspended person to operate, 24 operating without a license. In 06, an MIP, another one in 06. In 12, an attempt to resist and obstruct. In 12, attempted jostling. 18, a plate violation. 19, no license. And open intox. And 24, there was a use of methamphetamine. The praxis scores him at a risk level 3. Any comment regarding bond, Mr. Shantz?
Thank you, Your Honor. I had the opportunity to speak with Brian earlier today. He's expressed to me that he's been living in the Wexford area his entire life, although he's only been at his current residence for about a year, and that he has completed his GED, and that he currently works odd jobs, including cutting lumber and as well as working for a friend's landscaping company in order to make ends meet. I would like to highlight that he was picked up at the Misaki jail when he was visiting his girlfriend. He did not try to run when they informed him of his bench warrant, surrendered himself peacefully to authorities. I believe that reflects on the fact that, as he expressed to me, he knows that running always makes it worse, and he has no intent to run. It's my understanding that he's never failed to appear prior in any case prior to this, and he has never missed a court date. We would respectfully request a PR bond so that we can adequately prepare his defense against these charges. I understand that the people might think that Brian is a threat to society. I would counter that Brian's the greatest threat is only to himself, and not that he, insofar as he engages in self-destructive behavior, not that he would harm himself. But we would just respectfully request that PR, and I would also highlight that he has two kids with who have children of their own, so grandkids that live up here in the Big Rapids, Marion area as well. So he has substantial family ties, and I do not believe he would give up. Change the way he has approached any of these prior arrests or give up a chance to be a part of their lives by running. Thank you.
Thank you. Ms. Lawrence?
Your Honor, this started out as a traffic stop in which the defendant was found. I believe it was a small container with residue in it that did test positive for methamphetamine. I would ask the court to impose drug testing given the offense here. There was also other individuals in the car who either had narcotics on them or outstanding arrest warrants. So I would ask for the no contact order with the co-defendant in this case as well. I do think a monetary bond is appropriate given the defendant's prior criminal history. I believe I counted either 9 or 10 prior drug convictions. And he's also facing a potential lifetime penalty here. So I would ask the court to impose a $50,000 cash surety bond. Thank you.
Thank you. Ms. Lawrence, do you know, is the co-defendant's case still pending?
Yes.
It's still open? All right, Mr. Harsh, as conditions of your bond, I'm going to order that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also ordering that you not consume any illegal controlled substances, no recreational marijuana, and you'll be subject to random testing as well. I'm also ordering enrollment in the EOP program. That's extensive outpatient treatment. I believe that is appropriate given the nature of these charges. My reading of the probable cause affidavit indicates that Mr. Harsh had told law enforcement that it would test positive for a substance, although not the substance that it tested positive for. I also believe that EOP would be appropriate given that the last drug conviction was back in 24. So given those, the allegations in this case and the defendant's history, EOP is appropriate. I am going to, at least for right now, until I know more, ordering a no contact with the co-defendant in this case, Heather Schmuck. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. I do not indicate, the praxis does not indicate that Mr. Harsh would be a flight risk. So I am going to release Mr. Harsh first recognizance, which is your promise to come back to court. Hold on, hold that thought, because there is a financial review that you failed to appear for back on January 23rd of this year. And the court authorized a bench warrant on that one with a personal recognizance bond. Although it does look like it was sent to a different address. So I am going to continue the personal recognizance bond as I was going to do. Mr. Harsh, I see you had your hand up. Is there something that you wanted to say?
Yeah, was that other thing for friend of the court?
No, that'd be for fines and costs here in the district court.
Oh, all right.
So while I've got you here on that, looks like you owe the court $2,707.60. Are you able to do any type of payment plan on that?
Yeah, I can.
How much can you do?
At least 10, 20 bucks a month, if that's okay.
I'm fine with that. As long as you make some sort of payment, that's all I ask for. So
Yeah, if I can't, I'll make a payment before, I don't know, this week if I can.
all right. So what I'm going to do is I'll put you down for $10 each month
All right,
by the first of the month.
all right. Thank
And then
you.
what I'm also going to do is I'm going to reset this in 3 months. If you're keeping up on your payments, we'll cancel it. But if not, I'm going to expect you back here and we'll discuss your finances some more. Okay.
All right, thank you.
So at some point, you're going to be released from the jail today. You will have your next court dates when you're released. So make sure you keep track of those. And then you'll need to come over here to community corrections at the courthouse and get signed up for your testing requirements. All right.
All right, as soon as I leave here,
I'm sorry.
I said as soon as I leave here, I go to the community corrections.
As soon as you leave here, come to 5 or 6 blocks to community corrections.
All right, thank you.
All right. Thank you.
Clayton swung a blade, laid out in the park, left a nasty cut, bleeding in the dark. Brian had some meth hiding in his car. Now he takes his test, hoping he goes far. The gavel comes down heavy and the bond is set so high. Better change your risky ways before the long years pass you by. Keep your hands to yourself and leave the drugs behind, or the inside of a cell is all you will ever find.